all the comments this afternoon have been changed or set up by the people on the Zoom, nobody in here.
I have noticed that. All right, let's go back on the record.
Yeah.
Hey, everybody, let's go. John? We're going to, before we get back into 76A, Bill Boyce prepares some alternate language called a permissive option and mandatory option from this morning, and it's all been sent to everybody. You want to try to pull it up? We're going backwards, Marcy.
We've been going backwards all night, Jim.
Yeah, it's true. We're back on the Rule of Judicial Administration number 10. So everybody got it pulled up? All right, the permissive option modeled on miscellaneous docket number 22-9053 says, as adopted to this rule, with respect to procedures under chapters 573 and 574 of the Texas Health and Safety Code, and I guess it's up on the screen right now, use of forms approved by the Judicial Commission on Mental Health is not required. However, a court must not refuse to accept a filing simply because the applicant used the approved form or is not represented by counsel. The court should rule on a filing, little typo there, without regard to non-substantive defects. And then the mandatory option, which is modeled on order number 22-9053, as per Judge Peoples' proposal, with respect to procedures under chapter 573 and 74, a court must use forms approved by the Judicial Commission on Mental Health unless the court obtains prior approval from the presiding judge of the region to use an alternative form. A court must not refuse to use an alternative form. Must not refuse to accept a filing simply because the applicant used forms approved by the Judicial Commission on Mental Health or is not represented by counsel. The court should rule on a filing without regard to non-substantive defects. Any comments on those two versions? Any questions of Bill? We got a hand up by somebody, but I can't see it. Who's got their hand up, Shiva? Justice Gray. Well, yeah, but he's here. Come on. Come on up.
Come on up.
This is Price is Right. Come on down.
It's not worth the trip. If judges don't do filings, accept filings.
Judges-
In this context,
Judges don't do filings. They don't accept filings in this context, but this is not worth a trip for Justice Gray. All right, but there was a remote comment. Who is it, Shiva? Professor Hoffman?
No, that's back to 76A.
That was left over from the 76A discussion.
Okay, so anybody, okay, we're about to take a vote. Everybody is in favor of the permissive option, raise your hand. Okay, how many online? All right, everybody in favor of mandatory. Is that up? Is your hand up? Lisa, is your hand up?
I walked in and I didn't realize there were two things. I was just focused on the second one.
We're voting on the one called mandatory option. The one that says mandatory option. That's what we're voting on now. You want to start over? All right, people want to start over. So Now we're voting on permissive option. So that's, if you're in favor of permissive option, not mandatory option, raise your hand. Permissive option, hands. It means what it says in that state.
Wait, this is permissive, right?
Permissive.
Ethan and I are fried. I'm sorry.
You are fried. How many online? All right, mandatory. How many online? All right, 18-2 permissive prevails in an upset. Chair not voting. All right, let's go back to Judge Yalanowski.
It's gone down.
Yeah, do it.
And Richard, let me suggest something. Rather than have Judge Yalanowski go through every red line,
Okay,
shouldn't we break it down? Sorry. Rather than have Judge Yalanowski go through every red line of the whole rule, shouldn't we break it down by, here's the red line in 1, discuss that. Here's the red line in 2.
oh, yeah, I think we should do it a paragraph at a time.
Okay, good.
Because you may want to take a vote.
That's what I was thinking.
Okay, Steve Sealer, are you there?
Yeah.
Very good. So the first paragraph is the standard for sealing court orders, which only had a small change. Stephen, explain it.
The standard, well, the small change, the big change is the reference to 3A, right? So that links it to 3A. And that's why it's except as provided below. Because 3A has a different presumption. And so the standard for sealing court records is the traditional openness, and the standard under the proposed 3 is a presumption of confidentiality. So that just links it to that. The only other thing I'll note there is that we're using the word information carefully, as well as the word document, with the understanding that sealing may be information within a document, and that's important, often ignored, I think, when orders are signed, but it's important to distinguish a document from information within it that might be a very small part of the document.
So Stephen, it says, the old rule says no court order or opinion issued in the adjudication of a case may be sealed, and then we've introduced an exception as provided below. Can you give us a preview? What's accepted?
Well, that's the 3A that you went over very well, I think, and covered very well initially.
Now, is there not at least one instance in which there's a statute that requires that a judgment or order be
Oh, yeah.
unsealed? So we can't have an unqualified ban against sealing all orders because there are some statutes that require it, right?
Well, you've listed one, so I don't know if you caught them all, but you listed one.
Okay.
Yeah.
So at least we're recognizing now that there are instances in which an order can be sealed. So then we'll go on to number 2. Court records are all documents of any nature filed or sought to be sealed before filing. So we have to add that because of our notice of intent to file sealed documents, right?
Well, forever, lawyers have, I think, properly, and judges have said, well, you don't have to file the document unsealed in order to fall under 76A. That would be counterproductive, to say the least. So it's always been interpreted to mean sought to be sealed. There's a motion to seal a document. It's not filed. The document's not filed. The motion is presented, et cetera, and then it's either sealed or not before it's filed. And if the sealing order is disallowed, then there's a question not addressed in here, which is, well, can the lawyer then just withdraw the motion to seal and not file it? but that's not addressed here. But the reason for sought to be sealed is for that.
Okay, Ken and Wooten is going to come up here, I think, to make a comment.
Wonder if it would be a little clearer if we said, or sought to be filed under seal.
Don't have a strong reaction to that. So
We're going to make a note of that. Now, subdivision 2 has court records and then it has 4 exceptions. 1 and 2 existed before. We've added court orders required to be sealed by statute to recognize that once something is defined to be a court order, then it's in play, but there are some statutes that'll never be in play no matter what. So we're going to exclude them from the definition of court records.
yeah, and I guess I missed it up at the top, and that's also where an exception exists for orders.
So now paragraph 3.
Well, before you leave.
All right,
too,
Chip Babcock has a comment.
Sorry, normally I don't get involved in these things substantively, but
But you're a First Amendment lawyer,
I
Chip.
happen to know something about these.
Maybe you want to just take over the whole presentation.
No, I don't think I should. But I do appear to be fuzzy for some reason. Now I'm clear. You said that you all didn't take on 2C, which is discovery not file of record. And to me, that paragraph, which is, you said was controversial, but at the time, and Chief Justice Eck will, I think, confirm this, none of the interest groups other than Justice Doggett, and perhaps some plaintiffs groups, but I don't think so. Certainly not the press groups who are advocating this. And it got put in here nevertheless,
Mhm.
and it has led, in my opinion, to most of the mischief in this rule, if not all of it.
Well, Chip, let me say that having reviewed the historical record, I agree with you totally. And not only that, but this came in on the 3rd day of the committee meeting, where less than half of the committee was there and barely more than half of the people that were present voted in favor of it. And Luther Souls, who was the chair of the committee, wrote a letter to the Supreme Court objecting to the way that occurred, and then the relative change in the discovery rules about confidentiality agreements. So it was hugely controversial. I would also say that in addition to Justice Doggett, there was also a contingent of plaintiffs' lawyers that wanted to make discovery on products liability available to other plaintiffs' lawyers. And their justification was, I've spent $300,000 finding about this defective part from General Motors, and it's the same car that's involved in this lawsuit. Why should they have to spend $300,000 doing the same discovery? So they wanted the discovery to be saved. And then some defense lawyers wrote letters into the record after the fact saying that they were creating a secondary market for the sale of discovery information for a fee. And so it was hugely controversial.
Yeah.
And perhaps we should look at it. Chip.
Yeah, and I think we should, because by keeping this in here, it leads to the problems that you find in 3A1, and it leads to the problem that you find in 3A3, because as you say, these protective orders that are often, if not routinely, entered are basically sealing orders in disguise.
Right.
But if unfiled discovery is taken out of the rule, then there's nothing wrong with them, because unfiled discovery, the court can handle it and the parties can handle it as they wish. But really, technically, every time you do one of these, protective orders by agreement, you arguably are violating 76A, which is not a good thing. But you don't want parties to be able to, by agreement, go to a judge and say, we want to protect things that already in the record. That's what led to this whole thing. There was a case involving a psychiatrist who was alleged to be having sex with his patients and causing all sorts of harm. And the psychiatrist through his counsel was after the case was settled, sealing all the pleadings, not just the records, but the pleadings in the case, and doing it by agreement and getting an order entered sealing record. And later on, a newspaper got onto this psychiatrist, went to look at the court file and couldn't find it. So there is
What was that, the Times Herald case?
Tuttle and Jones versus the Times.
That was, to my observation, that was the first sealing appeal that we had, Chip, and you were the lawyer for the
That's right.
Dallas Times Herald.
That's
In
right.
fact, you started.
I started this whole mess. I was not alone, however, in starting this mess. But in any event, the unfiled discovery, you sort of need something like this if you're going to have unfiled discovery. But my point is, you ought to take a hard look at unfiled discovery.
I think we should.
Okay.
Let me
That's my
also
point.
say though, Chip, that you may still want information subject to a confidentiality agreement or protective order to have a certain presumption. Maybe you don't. That's maybe one of the more controversial parts of this. But we're in paragraph 3, we're attempting to define things that at first blush is not going to be an assumption it should be public. There's reasons to think that it shouldn't be public, and someone should come forward and prove why.
That leads to another question. Have you all found any 76A type rules in any other jurisdiction, principally Florida would be a comparable jurisdiction, where there's a presumption of confidentiality as opposed to a presumption of openness? The ones I'm familiar with do a presumption of openness, and they leave it to case by case basis on whether something is confidential, unless the statute makes it confidential. So this would be a departure from a rule that is perhaps too open to one that is among the most closed of the states that I'm familiar with.
Okay, so you had
Can I
mentioned
speak to that a minute, Richard?
Go ahead.
Well, I think earlier Richard pointed out TUTSA, the Trade Secrets Act, which was reviewed in, oh gosh, what's the case? I can't think of it. What's that?
It's reviewed in House
House
Committee.
Canary, yeah. And in House Canary, it refers to, well, it uses the word presumption a couple of different ways. And substantively, it refers to the Trade Secret Act sort of switching the presumption from openness to protection. It also uses the word presumption with respect to 76A procedure, which I think is confusing in the opinion. In any event, if you separate those two, they seem to be saying that the Trade Secret Act does, with respect to trade secrets, exactly what 3A would do to trade secrets and other things.
Well, the and other things, and by the way, TUTSA, which is the Texas Uniform Trade Secrets Act, by its terms, applies to cases originally brought under the statute. It's not so broad as to apply to all trade secrets, because
Right.
there's lots of litigation where parties will try to hide behind trade secrets and not producing documents, and you get in a whole big fight. And the case has nothing to do with trade secrets. It's not brought under the act. It's just trade secrets are involved. So you got to be careful about being too broad on something like this.
Well, I think so. If I can just say overall, Chip will certainly remember when my hand was up every time that Richard uttered a word about 76A. And as you said, I was either doing that to speak or to go to the bathroom, one of the two, but it seemed very urgent. We've come a long way since then. Richard and I have a lot of agreement. We have a lot of disagreements on what should be open and that kind of thing. But I realize anyway that something needed to be done to address all the complaints about 76A and it being too burdensome with the typical trade secret or proprietary matter, even if it's not brought under the Trade Secrets Act. So to me, I'm sorry.
No, go ahead. I'm sorry.
Well, it's to me, I mean, in terms of not the drafting, but just how I feel about it, I think there are some countervailing things that are very important in this rule, regardless of what we do with 3A. And if it's going to require something like 3A in order to get the rule through with some of the other changes, that's a policy and I guess sort of political question that I can't answer, but there seems to be a consensus or a large sense of the committee that, as I understood it, and I argued against it, but it's still there, that it is too cumbersome. 76A is too cumbersome in the typical case where it's employed. So if this is not the way we address that complaint, then I'm thinking there needs to be another way to address that complaint, because my understanding, the impetus for the charge or referral to us from the Supreme Court was largely on the complaint of attorneys. Of course, I can't say that's why they did it, but it was subsequent to those complaints. So my point is just that I don't support the idea of switching the presumption, but I think that there's a sense that we need to do something that would make it easier to use for these types of.
No, I hear what you're saying, and at least the attorney complaints that I'm aware of stem from 2C. But to the specific point about trade secrets, if you're trying to capture TUTSA, you're going to capture that by 3A2, because TUTSA is a statute and it has its own procedures, and it is outside 76A. As the court,
Trade secrets are also confidential under the Texas Rules of Evidence. And
they are.
they're not constrained by the statute.
And the problem is what's trade secret, and the problem is also what's other proprietary information. We all know you get in discovery fights, and the other side won't produce stuff because they say, oh, it's proprietary, or they want to make it attorney size only. There are a whole bunch of problems that are raised in discovery, appropriately so if you got 2C in the rule. But if you don't have 2C in the rule, then you can fix that, in my opinion. Sorry.
Okay,
No,
so
and
let me say that the practical effect of having a paragraph 3 is two things. It recognizes a privacy right that reverses the presumption, and it also establishes a category of information that if someone wants to file it sealed, that order will be granted if within 14 days of notice, no one has requested a hearing.
unless
the court.
the judge says, and hopefully judges scrutinize it enough to say, well, you said this is a trade secret, but I've looked at it and it's not. So it's not under 3A. What's it under? And if they say, well, it's under 3D or 3.4, and the judge says, no, it's not, then the judge is in a position to say, this is not a 3A case. And as the rule is drafted, late on, I think we added that sentence that says, if the judge says it's not 3A, you can still go through the normal procedure and the normal presumption, which is openness.
And so just to make it clear in the record, even if no outsider or party files a motion to contest or seal, I think the trial judge always has their prerogative to review the documents and make the decision themselves that I don't buy that. Let's have a hearing. I want more before I'm going to seal this. So I think that's should be made more explicit. But Chip, from the standpoint of what's in paragraph 3, the effect is it reverses the burden and puts the burden on the party attempting to get the unsealing to show a probable adverse effect on general public health or safety. And we might consider adding honest government. In the undisclosed discovery, it was more than just public health. It was also public honesty. There was some, if you look at the exception on the unfiled discovery, says probable adverse effect on the general public health or safety or the administration of public office or the operation of the government. So I'm thinking back to some of the scandals that we've had here, even in Texas, involving, so maybe it shouldn't just be if people are going to die. Maybe it should be if criminals are running our government. We ought to have, the public ought to have enough knowledge of what they're doing. So at any rate, it reverses the burden of proof, but it also creates a default, an environment in which unless someone says, I want a hearing, then you won't get a hearing.
I don't want to do a little CBS point counterpoint, or what did they do on Saturday Night Live?
forgot.
Anyway, they spoofed it. Think about how this is going to come up, where you need a sealing order. If you take unfiled discovery out of it, then if I'm going to file a motion for summary judgment, right? And I say to my litigation opponent, hey, I'm going to use this document and these pages from the deposition, and I want to file it, and that information, if it's relevant, will be used by the judge to make a determination, and the public is entitled to know what the judge bases her decision on, right? But there are countervailing arguments. So if it is something that is privacy, for example, then the litigation opponent will say, no, I don't agree to that. We're going to have to go to the judge, and it's going to have to be sealed.
Okay.
There shouldn't be a presumption about that. It just is, it is or it isn't. But the amount of work the judge has to do is infinitesimally smaller than if you just have this whole broad category without being tied to something that the public has an interest in, like a summary judgment or a motion to dismiss or a trial or an injunction hearing, some limited amount of information which the public would have an interest in because a judge is going to rely upon it to make her decision.
So let me
Can I respond to
recap.
that, Richard? I agree with that. And as a practical matter, I don't think what we call the presumption, whether it's openness or otherwise, like you said, Chip, it either is or isn't something that should be protected. And there is a lot of focus legally. I mean, the professor from Texas Tech argues that, well, you can't have a presumption of confidentiality that's consistent with the First Amendment and common law. But all that argument over what the law is, as a practical matter, I think the bigger concern is whether we call it a presumption of openness for anything or confidentiality, is whether the judge does his or her job and actually scrutinizes this stuff. And we can't really write that into the rule. But if people like me don't like the presumption of confidentiality, I don't know really, Richard, that it's going to make a lot of difference there, except that there's the provision says that, if the judge doesn't determine that 3A doesn't apply and nobody asks for a hearing, then the judge shall, right, seal it. So that's a functional part of it. But the presumption of openness, I think, needs to be stated. But either way, the real issue is are judges giving this serious attention under any standard?
So, Chip, my reaction to what you last said is that we don't need 3A3, information subject to a confidentiality agreement or protective order, if we take unfiled discovery out of the definition of court records, because unfiled discovery will not be a court record until somebody says, I want to file it. So if we take that unfiled discovery out, then we don't really need 3A3.
Or one.
Well, you say one, but there is a rule of evidence that makes trade secrets confidential, and it's not the same as the statute, and it applies at all proceedings, not just proceedings under the
Your
statute.
3A2 says under Constitution, statute, or law.
I get your point. So 2 would subsume the rule of evidence as well as the statutory rule.
Sounds like it's amazing.
Sounds like we're editing on the fly here, Chip. That's okay with me. Yes.
Who didn't want to do that?
Can I
They're
disagree?
coming from all sides. I'm gonna get.
No, now you're in trouble.
Uh-oh.
Believe me, but he doesn't have his notebook, so.
He has some paper.
Richard, can I comment on what you just said?
Yes.
So let me begin by saying I like these changes. And let me also say that from a practitioner standpoint, 76A is a major pain to try and comply with, and I'm not sure that it does much good. Every time we produce documents in cases all the time that are confidential to the producing party that the public could care less about. There's no public interest in those documents, how the client goes about doing certain things or other confidential information. And that ought not to be made public because it can be obtained by competitors, can be obtained by others. And we need to be able to file that with the court and have it protected from being a public document without having to go through 76A. And if your newspaper, Chip, if it finds a motion and there's documents in there that it thinks that it wants to get that are filed under seal, and I want to come back to that in a moment, you have the ability to intervene and try and get it unsealed and argue that it should be made public. So I think you do need 3A1 and 3. I will also point out that in almost every confidentiality agreement or protective order, there's a provision for the receiving party to challenge any confidentiality designation. So if I produce documents to Chip and I mark everything as confidential under the protective order, Chip has the ability to go to the court and say, all this stuff should not be confidential. It doesn't qualify as confidential. And if he wins, then it's then not subject to the protection of the protective order, the confidentiality order. And so that plaintiff lawyers, if they think that information is inappropriately designated, they can challenge that designation. Let me also point out something, Richard, that I think you should take into consideration, and that is, it's been my experience that many clerks in courts across Texas don't know how to seal documents. And so if I file a motion for summary judgment and I say to the clerk, I'm filing documents that need to be sealed, they don't know how to do it.
Well, yes, that's an issue. There are a lot of practical issues, but it doesn't really pertain to the rule, I don't think.
Well, I was going to suggest, here's how we normally do it. And I was going to suggest this as you all may include this. So what we normally do is say that documents that are marked confidential that need to be filed with the court are filed in camera. And so there's a problem with that because you're circumventing Rule 76A. I get that. But you all, I think, should address in your proposed rule how it is you file documents that are covered by 3A. How are you going to file those with the court if they need to be filed with the court? It's just a suggestion so that we can get everybody in compliance with 76A.
With regard to that last comment, Alistair, there's in the federal system, you can file confidential. And I know Just Estevez's system in her district allows you to file confidential, and they use it frequently in criminal matters so that it can be electronically accessed by the judge, but not others. And I know that Judge Miskell said here during the recent break, am I not right, that in Collin County, there is a way to electronically seal something so that only the court sees it and the public doesn't?
Technologically, yes. District clerks will not accept documents filed under seal.
Okay, so technically they could do it, but the district clerk won't accept documents filed electronically. But in Bexar County, under seal, I'm sorry. Yeah, in Bexar County, we're told that you have to file it in paper form if you want it to be sealed. They just can't. And it's my understanding that the general statewide electronic filing system doesn't permit you to designate something. So right now it's just the primitive hand delivery in the envelope with duct tape is the way you file sealed in Texas. And until we have a uniform, more sophisticated system like the feds, I think that's what we have to do.
Richard, can I respond?
Please, please.
To the point you made about, well, we don't, now I'm just following what I think is the logic here, since I've already said, it isn't something that I would choose, but the logic that I see of A3 is that if there is a protective order, right? And then later on, the parties agree, let's say, to protective order confidentiality on the discovery. And then later on, one of them wants to file it. Do they get the presumption or not when they go to the court? So the way it's written here, they would, even without the discovery provision in 2C, they might want to file it. And does the fact that it was under a confidentiality agreement flip the presumption? That's what I thought you were doing with 3. It's discovery, yes, but what you would do under 3 is not just 2C. It's filing something that has been under a confidentiality agreement, and does that give it some leg up on the presumption, or switch the presumption when you go to court? That, of course, would open it to attorneys agreeing to things that they shouldn't agree to, so they can get this advantage, because the attorneys often agree they want to seal it. Of course, then that then relies on the judge under B to say, well, no, you all agreed that this was subject to a confidentiality order or protective order, but that was just a sham.
Well, the historical record in the 1990s was that, and the ability of the parties to agree that documents produced voluntarily in discovery would not be filed because of a confidentiality agreement, which was frequently a confidentiality order, in fact, allowed the courts to avoid a lot of hearings over discoverability of certain things. In other words, people were motivated to fight discovery if they were afraid that once the document was turned over, it could be filed unsealed. And so it eliminated a lot of discovery fights. And there were people that talked to the Supreme Court in its public session, as well as in the committees and letters, that there's a bona fide reason why our system might decide to defer those discovery fights from every instance to just those instances in which someone wants to file some discovery of record. So there is a salutary, yeah, that was Chip's point, okay? So Judge Miskell, I don't know if you wanted to talk and gave up, but please. Oh, I'm sorry, Robert. Oh, gosh.
That's all right. Mine was super short and not.
Okay.
Don't know, just to clarify. Okay, sorry, I'm cutting in line because mine is super short and not substantive. I wanted to clarify the previous question about district clerk accepting documents under seal. And if there's an order signed, the district clerk will accept documents under seal. They do have to be hand delivered. It can't be e-filed. But without an order, you can't just on your own submit documents under seal, is my understanding. So if I misspoke before.
At last.
Well, I wanted to respond to Chip's comment. I do agree with you about the issue in 3C, but there, I think, still will be circumstances. I think Steve Yalanowski referenced 2C, correct. I'm sorry. Steve Yalanowski mentioned those types of situations where you would have, let's say, a confidential document that's subject to an agreement that's outside of the litigation that would be used in a motion to compel or a motion for protection or something like that, where it does become part of the court record. And so then the question is, how do you deal with that? And so the idea here would be to try to streamline the process and also protect the interest of both parties as well as third parties who might have an interest in that information.
Richard.
Well,
First, I want to just say, ton of work. Thank you. You can obviously tell you spent a lot of time on it. I'm a little confused about paragraph 3. And so I want to just kind of walk through a scenario. I want to file a motion for summary judgment. And my motion for summary judgment is going to have some documents that you produced that are business documents, but you never designated them as a trade secret. You never designated them as proprietary. And I file the motion. The other side comes back and says, those are trade secrets. That's proprietary information. I think I'm now subject to sanctions, even though you never designated them as a trade secret or as proprietary information. The same thing for privacy. You produce a document and I decide to use it, and it inadvertently has somebody's social security number on it. And it shouldn't have, and I don't notice it, I file it. And then the other side moves for sanctions, and you never designated this as confidential, and nothing told me it was confidential, and I didn't see it.
Why is that? Why do you think that's sanctionable?
Well, because I will have filed something that is a trade secret or other proprietary information, or that is confidential under a statute. And the sanction says if I do that, I'm subject to sanctioning. So I think you may need to say something like information designated as a trade secret. It can't be that somebody after the fact looks at it and says that was a trade secret or that was proprietary. It has to be a party actually designates it as a trade secret or as confidential. I don't want to have to try to figure out every statute that's out there. I don't want to be at risk that I missed the statute that's out there. It should be the other side tells me, don't use this document because I think it's protected.
I can understand that, but Richard has made the point that several times in our meetings that a plaintiff's lawyer can come in before there's any other ruling in the court and just attach something to the plaintiff's pleading. So the other side doesn't have an opportunity to get to designate it.
Well, if that plaintiff's lawyer has gotten it through some public means, I don't know why they would be criticized for using that document.
Well, they might.
Are they
They wouldn't
supposed
necessarily
to?
have. Richard can answer that. I'll let him answer it.
Well, I just give an example. I have one case that's under the family code, so it wouldn't be governed by this rule. But a bill of review petition was filed with 800 pages of exhibits attached to it. And they had some psychiatric records. They had a number of income tax returns, substantial numbers of documents that are confidential and self-identifiable as confidential. Filed a motion for sanctions. The judge never ruled on it. What I don't want is for a party who has confidential information or information that a judge might seal to file unsealed before the judge has a chance to rule on it. That's what I'm trying to avoid with this notice of intent. Now, your point is, well, wait a minute. They gave me 10,000 pages and I didn't know that there was a trade secret in there. They didn't call it to my attention. So maybe we do need to say that it was information designated as a trade secret or other proprietary information, pardon me, so that you have notice before you file. And that seems like a reasonable request to me, but I am concerned about the fact that any party today under Rule 76A can unilaterally unseal anything they want. And then the other side, their only recourse is to get a temporary order and try to get the horse back into the barn.
I feel like I'm arguing your earlier argument, Richard, which is what you just said. Somebody doesn't necessarily have an opportunity to designate before the other party puts it in the file, like your example on the bill of review. Did the other party have an opportunity to do that? Or is the other party going to always have that opportunity? I'm arguing your point that I thought I understood.
Yes, and I agree with you, Stephen. And what my view is that if we define this paragraph 3 correctly, we will have information that you're not supposed to file without giving notice to the other side that you're about to file. That's one of the functions of 3.
Okay.
Well, I think you're talking about two different things, but Professor Hoffman has had his mechanical hand up patiently for, by my count, 20 minutes. And apparently the mechanical hand is cried uncle, and he now wants to speak. So Professor Hoffman, you're on.
Thanks, Tip. Thanks, Tip. So I look, there's so many interesting issues here and hard issues, but I would say that at least for my part, one of the big ones that we've talked about, sometimes we've talked around, but I want to maybe try to suggest that I think it needs to be a more central part of the conversation, is the question of whether there should be a presumption that something is sealed in the paragraph 3. And I'm specifically and most kind of significantly concerned about the third subpart there, the confidentiality agreement or a protective order, because I just think it essentially replicates existing practice where people can agree to things under either a low or almost no standard, as opposed to the meaningful standard that normally applies to seal something. So I don't know, I understand there are reasonable people can disagree about that, but I just want to flag that I think that that's in some ways one of the core debates we need to be thinking about. And I'll just say that Dustin Benham, who's been referenced a couple of times here, he's the professor at Texas Tech, has written a fair bit on this, also wrote to me about this and said, his concern is that it turns the standard from one that is considered quite strict to one that essentially is not strict at all. And he would point us to, among other things, that the advisory committee on the federal side is in the middle of the same conversation, and that the issues relating to First Amendment and common law protections that apply to openness are fairly widely recognized. And so, anyway, for whatever it's worth, and I think it's worth a fair bit, I think we need to be thinking about that question. And it may be that we could solve this problem by just simply taking out, or the concern that I'm raising, take out confidentiality agreement, protective order, maybe simultaneously, Chip, do what you suggest, which is take the unfiled discovery out, distinguishing discovery stage from the adjudicative stage kind of issues. I mean, that may be a nice way to balance that. But another question might be to ask, why do we even need to have a presumption in favor of sealing? In other words, the subcommittee has done this very thoughtful work about creating a process by which the judge pays close attention to, what should and shouldn't be here. Why does there need to be a starting presumption against openness? So anyway, I'll say all that. And then the very last thing I'll say will just be both a pitch and a preview. Richard mentioned it earlier, but the advocate normally doesn't get involved kind of in the middle of debates, but this seemed like a nice opportunity to do that from a time standpoint. And so we do. So we have this issue that's coming out very soon, and I will email it around. We've got articles from Professor Benham, from Justice Smith, who sits in Dallas, who's written on this before, from Tom Leatherberry, from Joe Cleveland, a number of people weighing their views on 76A. And then on the federal side, Judges Elrod and Willett have an article that kind of expands on a case that they recently sat on a panel on. I'll just quickly mention, because it is super helpful on this exact point I was just mentioning about confidentiality agreements or protective orders. That site is 990 F3rd 410. Let me just say that again, 990 F3rd 410. What's interesting about that case, among others, is it also underlines that this is really not a traditional left-right issue, the way that it often breaks. Right here are two more of the more conservative judges coming down much more strongly in favor of openness and against sealing. So anyway, we just have a number of articles coming out in the Advocate, and I'll circulate that. Thanks for everyone's patience in listening to me.
Thanks, Professor Hoffman. Sorry you had to wait so long to comment. Somebody's got their hand up. Was that Jim? She's got a lead on you, doesn't she? She's going to get here first.
Are we on 3 or are we still?
We're anywhere you want to be.
I
No,
know.
we're not anywhere you want to be. We're out 3.
Okay. Okay.
Got to bring some order to this. Yeah.
So I was on the subcommittee. I would describe myself as sort of in favor of, I'm an openness extremist. So I'll put myself in that camp. I did bring up some of these points in the subcommittee. They didn't win the day, but I just want to express them again here. I share the concerns about the word proprietary information. We looked through the statutes. It's not defined in the statutes. So we'd be looking at a dictionary definition, I believe, and then what stops people from just claiming everything's proprietary. My second big concern has to do with information that's confidential under a constitution. I could not think of something that is protected using the word confidential under a constitution. Typically, we use the word private or privacy. And my concern with saying that anything that involves a constitutional right of privacy is presumptively secret from the public just strikes me as extremely strange and wrong. So while I think the judge could have the power to grant a motion sealing information that may be private under a constitution in a particular case, I think it's dangerous and wrong to have a broad presumption that anything that touches a constitutional right of privacy would presumptively be sealed. And then on 5, I don't believe I brought this concern to the committee, so I'm raising it now for the first time, but an order changing the name of a person to protect that person from a well-founded fear of violence. I might look to other statutes that already provide us some standards for that. So I don't know if well-founded fear of violence came from a statute. It might have.
No,
but-
it came from me because of name change orders. They're not an exception under 76A. And so I wanted something that would allow me to comply with 76A because I've been violating it whenever a woman came in with a name change order and I sealed who she was.
Right, I don't have a problem with that concept. I was gonna replace the words well-founded fear of violence with something like a person the subject of a protective order under the Texas Family Code or Code of Criminal Procedure, or a victim of, another word that's used in the family code is a victim of an offense involving family violence, stalking, or harassment. So I would just suggest we borrow words that are used elsewhere in the statute that we already know what they mean. I think those were my concerns. So my proposal would be to take out proprietary in 3A1 and just leave trade secret. Under 3A2, remove constitution as a presumption and just leave that up to a determination. And then 3A5, I'm good with the concept. I would just tweak the wording to match words that are already used elsewhere in other statutes.
Chip and Richard, we can draft this as the committee wants. And based on the subcommittee, this was the draft. And I don't know if there is a consensus of the full Supreme Court Advisory Committee about what Lonnie said about presumptions here. We can't do the drafting unless we know that.
Right. And I think my thought was to go through this rule today. We have another 35 minutes. And then I'm going to seek the advice of the court to determine whether they want us to continue to discuss it and maybe, as you say, get the sense of the full committee on these various concepts. But at least we'll have one run through today.
Well, I'd suggest then we skip over 3 because the other stuff doesn't all depend on 3. It is independent of it because it applies whatever the presumption is.
Yeah. Well, there's 2 people who want to talk about 3 and one's in the wings right now. So Jim.
Oh, do you want to hear that?
He was next.
Okay, thanks. Go ahead.
Come on, Jim.
It's relevant to 3 because the rule or the draft is inverting the presumption, but it does have relevance to the next steps because of what I would observe perhaps is an unintended consequence of this, which is a substantial increase in judicial involvement over these issues, whereas 76A, for all its faults, has generally been a self-help process. Because let me give you a concrete example. Medical records in a tort case. In concept, they are confidential by statute, a federal rule, HIPAA as private health information. A defendant wants to file a motion for summary judgment with those medical records. That defendant now, under this process, has a predicate of having to come to the plaintiff lawyer to get permission to file 3 pages of medical records that are confidential by statute as attachments to a motion for summary judgment. And plaintiff's lawyer says, no, I'm not giving you permission to file those attached to the motion. We're going to go down and have a sealing. You can invert that from my perspective. One of the things that I see Alistair touched on is confidentiality agreements, extensive negotiations over confidentiality agreements to address discovery issues. And we get highly confidential, attorney eyes only, confidential, and all of those designations. And then you are confronted with, I've got to go to the court to contest those stamps and have the court involved in the hearings on individual pieces of paper involved in the scope of discovery, so that the appropriate motions can be filed with the court, not subject to the sanction that Judge Brown was noticing out of 13, because of the mechanics that exist in 5 and 6. And so I have a real problem with 3A3, because I'll give you another concrete example. A hospital would not produce their insurance policy, which is mandatorily to be produced, without a confidentiality order, because they claimed that the insurance policy was proprietary information. So even under the scope of mandatory disclosures under Texas law, you're now talking about a involvement of a judge over the issue of production of available insurance coverage, which is allegedly proprietary. And now you've got judicial involvement, a stamp that then would require additional litigation or hearings or involvement of the parties to be able to determine what could be filed as it relates to that discovery fight. And while 76A has been worked around and definitely could use some updating, the way the inverting of the presumption works in this draft, along with the mechanical elements on what has to be essentially agreed to for proprietary filings on what happens in filings in the vast majority of litigation, as opposed to, because I got no problems with trade secrets, quite frankly, but there's an unintended consequence here, I fear, of a lot more collateral litigation around something that right now is generally controlled by the parties pretty effectively. So that was what I wanted to say.
Okay, Judge. You're next.
All right, I want to talk as to why we have that 3A. When the subcommittee that put it together, we didn't want to change the standard. We didn't want to have 2 different standards. We wanted to keep everything simple. So if you keep everything the same and you have to meet the standard no matter what type of information you're talking about, the easiest way to do that was for us to find that it's coming in under the presumption of, and you're calling it the presumption of confidentiality, which I would disagree with that. It's just a presumption that exactly what it says, that 3A is being met. So and I think it's really, really important. I'm gonna take, where's Jim? I'm gonna take his hypothetical and I'm gonna change it a little bit. Because this isn't about the case in which you're doing the summary judgment, and yes, there's all these medicals. This is the case, and I somebody goes off and they get their 4th booster shot. Okay,
I've already had mine.
okay. Well, this causes this pregnant woman.
That's private.
Okay, I'm just telling you, it causes this pregnant woman to the next day to have preeclampsia, high blood pressure. She goes into some sort of pre-labor and her baby dies. So now we're getting all of the OBGYN's records and we have them all. And we find that she's had 3 abortions. And so now Mr. Defense attorney is thinking, I'm going to file a motion for summary judgment and I'm going to attach all of these because I can, because they're all under the same affidavit, because that's what they always do to me. I get thousands and thousands and thousands of pages to read that have nothing to do with the summary judgment, even though that's not what the rule says. The rule says they have to pinpoint it, but they don't. I get the full deposition. I don't get 3 pages. I get 2,255 pages of deposition to read for 3 sentences.
Summary judgment denied because you didn't.
No, they make it. No, I don't. I read it. So with that, that's the type of information we're talking about. I mean, not necessarily only abortions, but there's so many other issues that it's absolutely no one's business. It gives you a chilling effect. So this person now knows that there's this summary judgment out there, knows that they've got all her medicals, and maybe she wants to settle because she doesn't want anybody to ever know what happened 25 years ago in her life. And so now she doesn't even want to litigate anymore because she doesn't want to go through a motion to eliminate. She doesn't want to go through a motion to seal that's open and public to everyone. She doesn't want to have to file this and ask for a notice of hearing and post that what she's going to try to close. And when we think about more famous people and other individuals, I mean, there's a lot of private information. I went to an extreme case because I think that that usually gives you a better idea, but there are areas that we need to be protecting the right of litigation where people don't have to decide whether or not they want their information out there for the public for absolutely no reason, or they want to be able to litigate a claim that they have a right to. So I think making these changes makes our system better. And I don't necessarily, I'm not sold on 3A, B3, what are all the numbers we have. I think we can tweak those and make those better. But I think that we should come with a thought process of, yes, there's going to be things that we really do want to have people tell us before they file so that we can avoid that. That's it.
Let's see if, you want to say something?
Yeah.
Okay, hang on for 1 second. No, come on. Just want to make sure there's nobody there.
Okay.
Okay,
So Jim Purdue, I want you to listen to my analysis and see whether it reassures you about the possibility of we're inadvertently creating a lot of court hearings. The way I see the mechanics of this working, if you have information that you want to file in a summary judgment or a summary judgment response, the question is not whether you can file it. The question is whether you can file it under seal. So if it fits paragraph 3 category and you want to file it, then you would give notice that I want to file documents, the following Bates numbers or whatever. And unless you request a hearing on sealing, or unless the opposing party requests a hearing on sealing, or after notice, unless a third party, like a newspaper, requests a hearing on sealing, there won't be a hearing on sealing because it will automatically be sealed by operation of law because no one requested a hearing on sealing. So if you look at the mechanics of the rule working this way, that I want to file this category of information, I'm giving you notice that I'm intending to do it. If no one requests a hearing within 14 days, then it gets filed without being, then it gets, the court approves filing sealing. if you want it to be public, it's not a question of whether you want it to be filed. It's a question of whether you want it to be public or not. Then you can request the hearing. But it's only when either the plaintiff or the defendant or a third party requests a hearing that the judge will get involved. So does that make any difference? Is it less likely that we're going to be creating a plethora of hearings? So that's my thought anyway. I wanted you to consider.
Lisa?
Okay, Richard, you just said something different that's important to me than what you said earlier, or maybe it was Judge Yalanowski. But my understanding under the draft is that if somebody seeks to seal something, they give notice and somebody can request a hearing or not, but the judge is still supposed to do his job and actually review to see if this is something that really meets the standard for sealing.
Well, this rule doesn't require the judge to do that, but if we think it's the judge's option to do that.
Well, I just don't want it to be sealed as an operation of law when there are three interests involved here. The litigants and the plaintiffs and the defendants, but there's this public interest that has been recognized in common law and the Constitution, that the only person who really has the ability to guard that public interest is the judge, because the plaintiffs don't always care, because maybe they get more documents or maybe they get more settlement money, and the defendants don't always care because they want to settle this, they want embarrassing information out of the court system. But the one person who needs to care, if we care about open courts, is the judge. And so I don't know how it's drafted, and Judge Yalanowski, it might have been you who said it, but to me, it's important not just that something gets sealed as a matter of law, sort of like my motions for new trial are denied as a matter of law.
Not that that's ever happened.
But I guess I would write a rule that does give the court some obligation to look at what the parties are saying should be sealed and make sure it should be.
Let me
Can I respond while you're there? And you'll see the first comment, which I really wanted, that says just what you said. And frankly, as I've said before, what we tell judges they can do, must do, or should do isn't necessarily going to assure openness. For me, the key to this revised rule is, and I know you agree with this, we need to have real notice that, frankly, the media can pick up. And this rule does that by establishing so far we haven't talked about it, but nobody on the subcommittee has objected to an official website where all motions to seal will be available. And frankly, I think that's where the media will go and look for things that perhaps shouldn't be sealed. Not to say we shouldn't address what judges should and should not do, but as Lonnie said, we may not need to state that presumption. It may not make that much difference. Problem though, Lonnie, I don't know whether you think the Trade Secrets Act then violates the First Amendment and the common law as interpreted by the Supreme Court here. And maybe that wasn't squarely addressed, but certainly maybe it's dicta, but certainly the idea that there's a different presumption for trade secrets through the Trade Secrets Act is there and needs to be applied for Trade Secret Act cases. So anyway, back to that. I mean, most important thing to me is the ability of media or other members of the public to find out what's going on, because whatever we require the judges to do or ask them to do, they may not do.
So Lisa, let me get a little closer. The microphone will pick me up. We have a practical decision to make. We're either going to require judicial review when someone asks for it, or we're going to require judicial review every time there's a sealing question. And the cost to the system and the cost to the parties of requiring a judge to review every sealing order, no matter how confidential the information may be, there's a cost to that. One of the consequences is the judges probably won't do that because they're too busy. They're too busy having hearings where people are fighting with each other to take a bunch of stuff home and read thousands of pages to decide whether the public has an interest or not. So what this rule does, it's different from Rule 76A and different from what you're saying, is that we're not requiring judicial review of a certain category of information that everyone acknowledges has a privacy component to it. We're not requiring a judicial review unless somebody asks for it. And that's a trade-off. You don't get 100% review, but you don't get any phantom hearings either. And so to me, that's a policy decision and an important one.
And one we probably disagree on, so.
Because neither one of us are deciding.
That's right.
Okay, let's move right along to paragraph 3B. And that-
I think you've got Wallace. Ted Wallace up there.
Oh, yeah, Judge, sorry, Judge Wallace.
Thank you, thank you. I just wanted to follow up. As I understand the current Rule 76A, and I've had a couple of cases where there's been documents filed under Rule 76A and notices issued and hearings set. I don't think the judge has any duty or obligation to review those documents absent somebody coming in at a hearing and raising an issue. It's certainly been my view that I didn't have an obligation to make my own assessment of whether those were properly sealed or not. Normally, as a practical matter, what's happened, nobody shows up. And yes, you sign an order sealing the documents. Let me point out an area where I think this can be, the whole thing though, can be run off the rail. Normally in a garden variety wrongful termination case or breach fiduciary duty, whatever, where oftentimes opposing parties are seeking each other's financial records, things of that nature. Usually what happens is about the first thing before there's any discovery exchanged is the parties will enter into an agreed protective order before they ever, so in it, they set out the procedure of how they're going to designate what's confidential and what's not confidential. And therefore somebody can't just go running off and filing something that they're designating as confidential. But here's what happens in those cases. More often than not, they will put language in those protective orders, the lawyers will, that if the documents are going to be filed in court, either at trial or in a hearing, they can be filed under seal provided these steps are followed. And they'll set out, give the other side notice. If they agree unless they agree they shouldn't be filed under seal, they will be filed under seal. And then they go ahead and set out how, if they're used at trial sometimes, which I don't think I've ever encountered a case where they're used at trial. The point I'm making is they circumvent Rule 76A, I think. There's no language in there that says you've got to comply with Rule 76A before you go filing documents under seal. So I suspect if the attorneys get a protective order like that signed by the judge, I suspect they feel they're under absolutely no obligations to comply with giving notice to anybody as long as they follow their own little procedure of what they're going to do. Now, which is why, rightly or wrongly, I take my ballpoint pen and I interlineate, provided the documents or provided the procedure for sealing under Rule 76A has been complied with or something.
Chip,
They probably
ahead,
think
I'm sorry.
it's not my business, but I do it. Okay, that's all.
Chip and Judge Wallace, I think that this is a good example of 76A and the understanding of it. The first paragraph of 76A says, it says records currently now, court records are presumed open and may be sealed only upon a showing of all of the following. That, to me, says to the judge, doesn't matter whether anybody else files for a hearing or complains or anything else. I have the obligation. It tells me I can't seal it unless that's shown. And so seems you disagree with that reading of it, and the comment that's at the end of this one, and the sentiment that Lisa expressed, which I agree with.
Well, and I understand what you're saying, and you may very well be right, and I may have just confessed on YouTube and everything else, not doing my job, but I suspect I'm not the only judge who is guilty of that as well. But I see what you're saying. I agree.
Well, and I agree with both of you. You're doing your job, Judge Wallace, just as many judges are doing exactly what you described. And frankly, I think Judge Jelenowski is right too, that as long as 2C is in there and you have unfiled discovery at issue on a certain category of cases or matters, it's a very, very unworkable system. But the point I was trying to make was by creating these presumptions, you are changing the dynamic unnecessarily. Because if I'm going to file a motion for summary judgment and I want to use some documents that I've only gotten because I've been entitled to them under discovery, but the other side has advised me they're confidential, then I go to them and I say, hey, I want to use these 3 documents in my summary judgment motion. And they either say yes or no. If they say no, then I go to the judge and I say, Judge, I don't think these are confidential, but they do. I want to file them. And so as Richard said, they're either filed in the public record or they're filed under seal. If they're filed under seal, then the public is denied some opportunity to determine whether the judge has acted properly in granting or denying the motion. That's all I'm saying. And now I want to talk about paragraph 3B to the extent anybody's got comments about it.
Well, 3B is just a continuation of this discussion, I think. And that's all tied up in the very fundamental question we've been discussing about, as you said, about the presumption and whether it ought to be switched, because B goes away if the presumption doesn't switch.
Yeah, I think that's right. Anybody else have any comments about 3B? Sheba, are there any hands that I don't see? All right, let's go to 4.
Before we leave the
Richard's got a hand.
Yes.
He's got 2 hands.
Okay, so the problem with dropping 3B is what eliminates the requirement to have a hearing in every sealing case. The idea in 3B is whatever's in 3A, it's going to get sealed unless someone requests a hearing. It's going to get sealed by operation of law unless someone requests a hearing. If we take 3B out of there, then we're back to 76A, which Steve just read to you, that you can't seal unless there's been a finding that these criteria have been met for sealing. So 3B is where we eliminate the phantom hearings that no one cares about, involving information that no third party cares about. If we do away with 3B, we're back to where we are in 76.
Yeah, I mean, that's what I was saying, Richard. I think, 3B, we've had the discussion and the answer isn't here yet. But what you're saying is that what I think I said, which is 3B needs to be there if there is a change in the presumption, which you support. And all I'm saying is, well, if there's not a presumption, then there's no 3B because there's no 3A.
But the presumption is, in a sense, not the ultimate question. The ultimate question is whether the information fits in the category that requires a hearing before sealing. It could be the presumption is on the party wanting to unseal. It could be the presumption is on the party wanting to seal. But the critical question is if it fits category 3A, it doesn't require a hearing to seal unless someone requests one.
But that's also true under 5. That's true. That's true under the things that are covered by the presumption of openness. Number 5, motion to seal. Motion must give a brief description and must state that any person may request a hearing to be heard in opposition. May request a hearing. 7, if a hearing is requested. It applies to everything without 3B.
Okay, so Steve, let me ask you this. We know that Rule 76A is written now requires a hearing before sealing. Would you agree with that?
Yes.
Okay. And the whole purpose of 4 is about giving notice to the other side that you're going to
Right.
all their information unsealed. And the purpose of 5 is to give notice to the world that you're going to try to seal some documents.
Right.
But if that notice relates to category paragraph 3A information, a hearing is not required unless it's requested. If we
Well, what I'm
don't,
saying is a hearing is never required under this proposed revision unless requested.
even if you take 3B out,
Yes.
what is the language that indicates that, Stephen?
Well, 5 says you got to give notice that they can request a hearing. 7 says if a hearing is requested. And let's see. Got to post public notice. 6, if a hearing is requested. At the bottom, maybe there's a mistake somewhere, but my drafting was to make it apply to everything, and I think it does. The whole idea was that we have these quote unquote phantom
You guys are
hearings.
gonna have to take this outside here in a minute.
Yeah. Well, that won't be new.
Let's, yes. Yeah, Marcy, come on up here. What a welcome break from these two.
I think there may be a way to resolve some of these issues that are creating the controversy by avoiding the word presumption in 3, because what it's sounding like is a presumption that cancels out the presumption of openness that people are responding to. And I understand why that is. What if it instead you used like a prima facie case? Because to me, what Richard is saying, and I totally agree with, is we don't need a hearing in every case, and we need a mechanism to opt out of that. And one way to do it would be if you put on a showing of a prima facie case of privilege. And I agree, we probably need to drop out the confidentiality agreement or protective order. And if we can take out unfiled discovery, my life gets so much better, because that I've never understood why that would be a court document. I mean, it's completely unworkable in practice. And it takes care of a lot of things if we drop both of those out and go with something different. And I'm not wed to prima facie case, but something other than presumption, because what you're trying to do is create a second track for things that aren't presumed, don't have to go through a hearing process, is what I'm thinking. And I do like how that's set up. And then B works, and then everything else ties together. And I hear what Judge Yelenovsky is saying about the other features probably give rise to not requiring a hearing, but because it's been required for so long, I think we ought to state it positively and just come up with better words, maybe prima facie case if you're open to that, or something where you can create, you can put yourself on track too, which is I don't need a hearing unless somebody requests it.
Are you saying that it should be automatic if it's not under 3? You should be mandatory hearings? Because this draft doesn't do that. There's no 76A has mandatory hearings. This draft does not.
Okay, well then I think we just need to be very clear that there's no mandatory hearing. And maybe prima facie case puts you in a separate category. I mean, maybe I'm not following it, but if we're moving from, we used to have a mandatory hearing and now we don't, then I think that ought to be explicit. Because that didn't come across to me.
Thanks, Marcy. Okay, in the 4.5 minutes we have left, let's focus on paragraph 4. Notice of intent to file confidential information unsealed. Is the notice unsealed, or is it the confidential information is being?
Confidential information, intending to file it.
Right.
So the intention, the notice of intent should describe it without revealing the confidential information. And it could be base number so-and-so, something like that.
Okay, any comments on this? Anybody had time to read it?
One thing I think that substantive that people at least need to think about is the requirement that the party who wants to file something unsealed give notice to certain people, one of whom is somebody who has a probable interest, as this is drafted, which could be a little loosey-goosey, but that language might be something people want to change.
So, so I want to file a motion for summary judgment. And I want to include a document in it that I've obtained in discovery from the other side, and the other side is marked it confidential. And so, but frankly, I don't care if it's sealed or not.
Then you file your motion. In that situation, you file your motion of intent to file the document sealed. You don't object, they don't object. You file your notice at the state website. No third party objects. It's filed sealed automatically.
Okay, so now you have a judge deciding the motion, however, and basing his decision on a critical document, a motion dispositive document,
right,
that is under seal.
So the trial judge at that point can sua sponte, reassess, because it was sealed by default,
Why
right?
is he going to do that? He's not going to.
Well, I guess
Who is going to do it if it's not the judge?
now it's a three-way argument, but Chip, you
Discretion?
don't want me arguing with Richard, but I don't agree with that.
I don't. All right. I think we've not completed this as I had hoped, but we've got more time, and it will be at the next meeting. Except Lisa wants the last word, so come on up here.
It's totally unrelated, but I mean, it is related to what, but if the subcommittee is doing any drafting, if you're not gonna make the judge make a decision, like a determination, then will you reconsider your res judicata paragraph about that there what, like, I think you mean it to apply, like,
Yep.
if we have this hearing and the judge makes a determination and it's not just, you know, as a matter of law, just, I would make sure that's clear.
Yes, our view is the judge shouldn't have to judge the same thing twice. But if it was sealed by operation of law without judicial hearing and no notice or any, I mean, nobody was there, that shouldn't create a res
Okay.
judicata bar.
I just wanted to point it out in case they were gonna draft some more.
I don't think there is sealing by operation of law under this, but we can talk about that later.
Sealing by operation of law. Well, the great news is that we're going to recess exactly at 5 o'clock, as is our practice. Start at 9, end at 5. And in case anybody didn't hear who was online, and Judge Christopher, I'll recognize you in a second. Our next meeting is going to be September 29th and 30, and September 30th and October 1 at the TAB, a 2-day meeting. And Justice Christopher has a parting shot.
Well, I just have a little bit. So I get a bunch of documents that are marked confidential, and I just do a prophylactic notice of intent to file, motion to seal. And so then, you know, like a whole ton of documents that are described in this notice get sealed, but then I don't actually file them at some point, or I file them later. How do we keep track of them in the system?
Yeah, great point. Levi's got the answer, but not today. Levi, what do you want to say?
I know that this is subject to whatever the court would like us to do, but you said we're coming back to this. There's some things later that I want to address. We didn't get to today, but I have some issues that need to be addressed if we come back to it.
Be sure you're at the next meeting.
And I just need to remind you that the Red Sox are 17.5 games behind the Astros. Thank you. Have a great weekend.
Can you ask him to send us an email with this thought?
That's it. He's gone.
Oh, okay. Well, I'll send him an email.
So he can't send you an email.
No, I'll do it. I'll send an email.
We got through it pretty well.
Oh, we got halfway through it anyway.
I think it was very important. We
Oh,
didn't get any-
the day you